Hello, everybody. Thank you so much for the kind introduction. Thank you so much for inviting me. Hello to everybody I know and to everybody I do not know yet. I'm very glad to be here. So, yeah, my topic is de-identified, anonymized, or aggregated. A look around the globe. I have to admit, we have to look like from our perspective, to the west around the globe, because I tackle more or less Europe and the US, and I hope I find some more material for you about other countries. So why is this topic relevant? So in general, anonymized or de-identified personal data is not in the scope of privacy and data protection regulations. That makes it kind of interesting for various industries. So you could say that it offers freedom from the restrictions of privacy compliance if you don't take it the way we take it here, I guess, with respect towards the end user. So it allows for greater data utilization, but of course there are many benefits beyond this, the way I phrased it now. So for data sharing, facilitating research, reducing risks in general, or even retain data beyond the retention period for personal information instead of deleting the data. Because when data is considered anonymous or de-identified, it's not considered personal data anymore. But in practice, unfortunately, common definitions and clear guidelines are really lacking. And my main message today here, as I have this legal background, but I had intense conversations with my dear colleagues, like from the technology part. If you're confused about this topic, you're not alone. It's not our fault, it's the regulators. So the common starting point usually is, the golden standard, the GDPR, and the GDPR is not applicable if the personal information it protects is considered anonymized. Here we could first start with, I'm sorry that I, have this immense text here, but first we can distinguish between anonymized and pseudonymized data under the GDPR. And according to the GDPR, when data is considered pseudonymized, it's still personal data, and it would mean that it cannot be attributed to a specific person without the use of without the use of additional information, for example, a secret key. So encryption in general, I would say you can also interpret it differently, but encryption in general is considered pseudonymization because you have the key and then you can retract the information. Anonymization, on the other hand, needs to be an irreversible process. If it's reversible, data is considered only pseudonymized. So in regard to anonymized data, there is not even an article in the GDPR. It's always this recital that comes before the main articles, more or less the frame around the whole regulation. And recital 26 gives further directions and says that the principles of data protection do not apply to anonymous information, namely information which does not relate to an identified or identifiable natural person, in such a manner that the data subject is not or no longer identifiable. I skipped the rest because I don't have a lot of time and I'm really afraid going down some rabbit hole. Because in practice, whatever recital 26 may say, and I think it doesn't look very unclear, but in practice it is unclear because within the EU already, different member states have interpreted recital 26 differently, regulators have interpreted differently, the courts have interpreted differently. So in the end, there is still, in the EU, there's this absolute approach and the relative approach, how you should interpret this. So under the absolute approach, which goes back even before the GDPR, no remaining risk is acceptable to consider something anonymized. So there's no re-identification possible. There was even a document by this Article 29 Working Party saying that the original data needs to be deleted so that there's really no risk that ever again you can re-identify this data, which is also not very realistic. And on the other hand, there we have this relative approach, which says there's always a remaining risk. But actually, under this relative approach, this is super weak because there was only like one court case by the European Court of Justice in this prior case where it said re-identification should be only if re-identification is possible with legal means, then that's a risk. So they didn't take into account like, attackers, motivated intruders. So it's like both is really totally unsatisfying, and that's the status that we have today in the EU. There's no clarity. Then in the US, it's also getting increasingly complicated. It starts very clear here with the FTC blog post. I also can recommend the FTC blog post. They're very well and clearly written. This is from July last year. And it says that claims the data is anonymous or has been anonymous is often deceptive, so not properly, they're just claiming something that isn't true. And this is really a problem, so watch out because the FTC doesn't like that. So companies may try to placate consumers' privacy concerns by claiming the anonymous aggregate data, and these companies should be on guard because it has often been showed that re-identification, especially in the context of location data, the FTC says is not sustainable and not good enough. So the FTC is very clear on this. What is interesting about this is there is no US privacy law that uses the term anonymization. So the FTC uses the term anonymization, whereas actually the US state privacy laws and HIPAA, which we all know, of course, that it's kind of outdated in this regard, they use de-identified data. And it gets really more and more complicated because we have all these new US state privacy laws coming up, and they more or less copy-pasted the definition of de-identified data. Some of them are a little bit more sophisticated, like California, but in the end, it's kind of all the same. So de-identified data under US state privacy laws is defined, not reasonably identifiable, relate to, describe, be capable of being associated with or being linked directly or indirectly to a particular consumer. And most of the US privacy laws, for example, here in California, they have additional provisions, so it's even better than the GDPR, so the GDPR plus in that regard, because data is only considered de-identified if the business also takes reasonable measures to ensure that the information cannot, be associated with consumer and households, then publicly commits to keep that information de-identified and not tries to re-identify it, and contractually oblige any recipients to do the same. So this is really kind of solid and nice. What makes the whole thing really complicated then, and I personally think a bit messy, is that they introduced a new exception for privacy laws in those US state privacy bills. And by the way, it's already like that in California, Colorado, Connecticut, Indiana, Iowa, Virginia, Utah, and Texas. So they introduced something that all the legal people I've talked to couldn't explain to me what it is, or haven't even really seen, or maybe they didn't admit to it, I don't know. And that is aggregated consumer information. So aggregated consumer information is also accepted. So it's an exception. It's not protected under US state privacy laws. US state privacy laws do not apply to aggregated consumer information. And it's phrased, we cannot go down that rabbit hole now, but I want to just show you that this is really confusing. So every single conversation I had about this, what does it mean? What's the difference between aggregated consumer information and de-identified data? I don't know. No one had a clear answer. We were all wondering. And, I asked like really smart people. So I think that could be a loophole. And I would hope that there's more research and more, considerations about this, or more raising the question what that means, especially from practitioners like you are, because I think that maybe the regulator wasn't aware what he was doing here, and then others thought California is so great and copied it. So this is really, it's risky. So I need to go back, because I just want to show up then that the confusion also stems from using the same terms for different things, because also under HIPAA, we have de-identified health information. So it's also de-identified, but the level or the benchmark the risk assessment is way lower, because here we have the expert assessment or the safe harbor method to remove 18 direct identifiers. I think by now we all should know that this is really not de-identifying anyone's data, and it's not safe. But this is a law, I think, from 1996, and obviously not phrased in a technology-neutral way. So when we were talking with my friends, we were really like, are you kidding me? It's like, are you kidding the legal professionals because they cannot really give advice, and you're kidding like the technologists, because how can you put something into practice that is completely unclear? So this is an ongoing challenge, and unfortunately this question that I think we should be able, like the legal people should be able to answer, does, I don't know, K-anonymity live up to anonymization in the EU is in a legal sense? Yes or no, or at least if I describe the circumstances so they have the context. But it is really hard. So you cannot answer for one and the same, so for various use cases, you cannot say this works and this doesn't work, because even if you had clear guidelines, it would be challenging, but the problem is you do not even have those clear guidelines. Yes, so I think from your perspective or technology's perspective, you know, risk-based approach and doing the best you can possibly do without like completely making the data useless. If you have a legitimate basis, I think, you know, a very hands-on approach would be best. And there is something new, and this is the one and only ISO IEC standard I ever bought. So ISO IEC has a new standard, and it's the standard called Privacy Enhancing Data De-Identification Framework. The definition for anonymization is, I mean, not new. Anonymization is a process by which personal data is irreversibly altered in such a way that a data subject can no longer be identified directly or indirectly, either by the data controller alone or in collaboration with any other party. But what it really has is it has several assessments and describes those assessments in detail. So it has a context assessment, a data assessment, an identifiability assessment, and it also calls for a governance so that you really keep track of what's going on with the data maybe after you anonymize it, so that you constantly monitor it and manage it. So I can really recommend this standard. The downside is, of course, if one has not bought it, I mean, it's not public, so we're not supposed to talk about it. I mean, so it's a solution because it's really well done, but I mean, you cannot really write about it. And so maybe this problem will still continue a little bit. I also want to point out that NIST has done really good work. It recently released in January this year a new special publication, I mean the draft only, but still de-identifying government data sets, which I can also recommend. NIST has a privacy engineering program. In its privacy engineering program, it has a research cycle that wants to explore de-identification technologies. So you can submit de-identification instances. And also the European Data Protection Board wants to, already announced last year, to come out with a new guideline on anonymization, which it still hasn't published. I think they're also struggling with this topic. So to make a long story short, anonymization, de-identification can mean the same and different things. The legal risk assessments are unclear. ISO has a good approach, with the downside, of course, that it's not public. And this new clause with the aggregated data, I think this is really something that we should look into if we're interested in privacy. And for further information, I will post these slides on my LinkedIn tonight, and I will also post an article that I've written recently about this. I will also, Lea Kisner's article on anonymization from, I think, 2 years ago, so was one of the most read articles on the IPP website, so I will post hers, and also Damien's article, where you probably compare differential privacy and K-anonymity, because, you know, a lot of people think differential privacy is the golden standard for anonymization these days. So I will post a couple of resources, and I hope that was kind of helpful for you, or will be. Thank you very much.